Okay. All right. Can you hear me okay? Let me see if
I can hear you fine. Yeah.
because my I had to turn my Bluetooth off because all of a sudden it was on my phone. I'm like, no, and then the other monitor got real loud, and I'm like, shit, I forgot to turn off that Bluetooth thing. It always causes a problem, you know. So let me fix this over here. So we're going to start off by just reading our fair use notice because I think we need to. And is due to the social nature of this site. This channel may make use of copyrighted material, the use of which has not always been specifically authorized by the copyright owner. It's an application constitutes a fair use of any such copyrighted material as provided for in Section 107 of the U.S. Copyright Law. In accordance with Title 17 USC, Section 107, the material on this channel is offered publicly and without profit to the users of the Internet for comment and nonprofit educational, informational purposes only. The following work is intended to be shared, is free, and only for educational or commentary purposes. And I am not monetized, and I don't care if I'm monetized or not. I'm just going to go ahead and put it out there. So here we go. Let's put ourselves up on the screen, and we'll get to talking about this. Here we go. Let me get this over here. Oh, come on. Let's go. Take that off. All right. And there we are. Look, there we are. All right. Now,
There we are.
all right. We're going to talk about the Murdaugh appeal, which I'm pretty sure is going to happen. I hope some people took the time to go watch the appeals hearings yesterday when they were live or on whoever's channel you wanted to watch them on. They were quite interesting, actually. I have not printed out this 182-page document. I was hoping to get my um, iPad to work so I could just read it from there, but it's not wanting to cooperate with me. I really do believe it's dead. I believe I'm going to have to replace it. And that makes me a little sick to the stomach, you know, because
Yeah.
that's expensive and I don't really want to do that. But so anyway, there and okay, I'm just going to start off with this over here. I'm gonna get it out of here and get it over with. And I'm not gonna discuss it again. I don't want to hear about it again. I don't care because the information that's out there is incorrect. We know that people want to cover their own asses at any cost. We know that. That's how people are. But I don't know how the hell you can be on a damn cruise boat for 8 days, minding your own damn business. Somebody sends you a picture and says, what do you see? Well, what do you think you see? You've turned it into pink or different colors. You turn the hue of it into different colors. Oh, I think I see people. All right. I don't know where it came from. I had no idea where it came from in the beginning. I had asked many times that this picture not be put on the internet. It should not have ever been used, and it damn sure should have never had anybody's names on it because you don't know where it came from. You don't know if it's real or not real, and that is the stance I have always had with that damn picture. The blob picture, whatever the hell you want to call it. But I can tell you one thing. I'm not going to sit here and be constantly accused of anything. I don't know Minnie. I don't know Sally. I don't know any of those people. I only know Lady Freedom and I know Star Lambert, and that's it. They both can tell you. I have asked them many times, do not put that picture up there. You don't know where it came from. When I finally found out that it came from Justin's live, that I think I was told Minnie clipped it and sent it to Lady Freedom, or Sally clipped it and sent it to Lady Freedom. That's all I know about it. Now, if you want to get back to some fuck shit, as you people want to call it, you need to go all the way back to at night, because I'm going to tell you one thing I have learned about all of this shit since day one, and everything has started flying out from under the rug. At night, whatever they call themselves are not what they appear to be. They're a bunch of keyboard detectives that don't even have a license. They're nothing. They're just they just sit over there and make a bunch of word salad. Now, they might have been hired initially to keep his name out in the public. Okay, we all understand that. That's fine. But you don't keep a missing child's name out in the public and start a bunch of drama and garbage and bullshit and then turn around and act like you did nothing. Because at night, you know what you did. You know you started a bunch of this. You know that you have created chaos. Then there's multiple creators over here creating chaos. If you want to know the truth about where this, whatever blob, as you call it, blob picture came from, you need to go talk to Lady Freedom. You need to go talk to Star Lambert, and you need to talk to Minnie or Sally or whatever her name is. I don't know anything about the 90 Day Fiance. whatever that was, I don't know. I don't know any of those people. And yes, if I choose to go and listen to Sinners Live every once in a while, that's my business and I will do so. It's none of your business why I go listen to Sinner. I might like want to hear what he's talking about that day. Period. You know,
Mm-hmm.
leave leave me out of the garbage bullshit. I don't have anything to do with it. You have all the
Yeah.
proof you need. Lady Freedom, Star Lambert, they've already put it out there
If you're
exactly
gonna
what their part was. Period. The end. I'm sorry, go ahead.
if you're gonna speak it, speak the truth. Don't
You know
don't
what?
speak lies.
Nobody ever came and asked me anything. Nobody. All of a sudden, I'm
Yeah.
hearing all this garbage being put out there once again a year later, a whole year later. Why? What do you think you're going to accomplish? Is it
Yeah.
wrong
It's
that people, is it wrong that people continue to use that picture? I believe so. I've asked hundreds of times for that picture not be shown. But it is none of my business what somebody else does with their channel. It's none of my business. And I can't tell anybody what to do, period. Everybody is their own free will. They can do whatever they want to do. It's called their channel, period. But I can tell you
mm-hmm.
this. I don't know what you're talking about. I don't have nothing to do with it. I don't want to be in the middle of it. Leave me alone. Please stop talking about me. And no, I'm not going to go on anybody's panel and discuss anything. You need to go watch whatever you need to watch to find the truth out. So you need to go over there to Lady Freedom. You need to go talk to Minnie. You need to go to Sally, whoever their names are, and that's where you're going to find the truth. And then I want you to take this
Mm-hmm.
all the way back to at night, because at night group is what I'm going to say has put out a lot of the stuff that created chaos in this case. Why? I don't know why. And you know what? I'm not gonna sit and try to
Yeah. What's the purpose
I'm
of
not
all this?
yeah, what is the purpose of it? What do you I mean, if you want to know, if you're trying to get to why somebody put that out, well, go ask them. I don't know. I have no idea. I can tell you one thing, I am not monetized over here. And I don't, and I probably am never gonna be monetized, but whatever. I don't need to make money from YouTube. This is something I do for fun. It's just a way to talk to other people and discuss the things that I want to talk about. And what I want to talk about is the court trials, the misinformation that is put out from court trial. What happens to these people in court? Why do people do the things they do? Why is there so much drama in true crime? Why do people take the lives of their children? Why do people kill other people? That's what I want to know about. And that's what I want to talk
Mm-hmm.
about. So from now on, my discussion is going to be the appeals that we're talking about, the cases that we're talking about as far as why people did what they did, period. That's it. There's really nothing more I can say about it, nothing more I'm going to say about it. That's it. Now, let's move on and start talking about Alex Murdaugh, period. All right? Alex Murdaugh. His hearings yesterday were very good, very, very,
Uh-oh.
what? What is it?
No, I didn't hear you for a minute. You went away, but I
Oh,
hear you again.
you're here. Okay, I need to get closer over here. Let me move my hair out the way. It's getting all up in the way. Very enlightening. This is very enlightening, and I truly do believe that what we saw yesterday from Sheed against the Leticia Stauch case, that she's going to win a new trial. I'm at 50-50 today. The more I think about it, I'm at 50-50 today. I really am.
Okay, you changed it a little bit.
Yeah, just a little bit, because I'm thinking, okay, now listen, because it all really comes down to this third degree of separation. I mean, I don't know how you. Well, let's look at it this way. Let me pull something up over here on that third degree of separation. Let me get my plug. Hold on. I'm plugging my little phone. I'm going to pull up third degree of separation and see what happens, because that's what the argument is actually.
Mm-hmm.
Okay, now, boop, here we go. All right, I'm going glasses. Okay, here we go. Okay. So when we talk about third degree of separation on a court case, okay, okay, here we go. Don't want to come on, participate now. Don't be doing that. Of course, it doesn't want to participate today. It's trying to take me
Uh-oh.
somewhere in Hollywood. It's trying to take me somewhere in Hollywood. I'm like, what do you mean? It's not a movie. God. Okay. Hmm. Challenge. It's a challenge in Supreme Court. Here we go. I wish I knew of other cases that had this particular problem as well.
I
But
know.
right now I
I
don't.
know.
I mean, I'm trying to find something. Mm, okay. It's not want to.
And like you said, the all of this bullshit,
Hmm.
the courts don't take the victims into consideration with this, and that's what's so sad.
No, they don't. It's like they don't care because the victims
Mhm.
are kind of irrelevant to what the law says.
Mhm.
And that's
Mhm.
what's hard about it because there's no way for them to think they can't think about it like that. I mean, it's really sad. So challenge for cause based
The
on the
re
third degree. I'm sorry. Go ahead.
That's okay. I was going to say the traumatization of the
Hmm.
victims with things like this is just out of control.
It is out of control, and it's really. And then we understand it's the law, and we understand that they have to follow the law. We understand all of that, but the victims and their families, and I mean, imagine how long it's been, and imagine a new trial for Leticia Stauch and her garbage,
Mm.
and imagine what's going to
Yeah.
happen when certain parts of that trial the are not they're not going to be able to
It,
use some of the evidence, and that's going to be a bad deal because it
yeah,
can
and it's
change
going
the
to take
outcome.
them. It's going to take them right back to it. Any healing that they've even begun to have is going to be totally erased. It's going to take them right back to it, right back to that time.
Hmm.
It's just awful. It's just awful. And then the
I mean,
fear of the conviction being overturned and the stress of that and the fear of her possibly walking. And I mean, I just can't even imagine living through something like that twice. I just
you,
can't.
you know that they're going to get a different psychiatrist to look at her this time. They won't use Dr. Lewis again. They already learned that
Of
lesson.
course not. Yeah. Yeah.
So we don't know what the new psychiatrist is going to be able to come up with by, and they won't show that video again either because they know that video
Yeah.
made them look like fools, girl, fools.
Mhm.
So
Yeah.
when we talk about this challenge for cause based on the third degree of consanguinity or affinity is a specific ground to disqualify a prospective juror due to a close relationship within the third degree of blood or marriage to a party, the victim, or an attorney, as outlined in state procedural codes and supported by common law principles regarding this juror and impartiality. So, key details regarding this challenge it includes this definition of third degree. That generally includes a relative such as a parent, a child, a grandparent, grandchildren, siblings, aunts, uncles, nieces, nephews, or in sometimes in-laws. See, here's the key word, sometimes, or in sometimes in-laws. What does that mean? Okay.
Mhm.
The
Very
purpose,
great.
I mean, think about that. That term right there is going to be, and sometimes is going to be the big question. The
Yeah,
purpose
shoot,
to
it's
ensure,
very great.
yeah, even though it's a small word, it's going to become very big in this case.
Mhm.
To ensure a fair and impartial jury by eliminating individuals with a direct personal or family connection to the case as described. Now, this is talking about the Texas Code of Criminal Procedures, and we realize that in this case, it's the Colorado Code. So, I mean, it's going to be a little different, but they're all basically the same when it comes to this challenge. Um, Now, the Supreme Court says while specific degrees are often defined by state law, okay, the U.S. Supreme Court, e.g., Batson versus Kentucky, regulates the overall constitutional use of challenges to ensure they are not used to discriminate, as stated in the Illinois State Bar Association and the American Psychological Association. Okay, so the challenge is part of the voir dire process where attorneys can remove a juror for specific articulable reasons according to the San Juan County, and this is Washington. So when you go to the Colorado Judicial Branch, which I'm going to go to that right now and see what we come up with. Oh, here's the actual statutes. Okay. Third degree challenge for jury in the Supreme Court. Now we're going over here to the Colorado case. Okay. Let's see. Where does it talk about that? I'm not going to read the whole thing, but I do want to read about their Colorado Code, criminal procedures. Okay, here, let me pull it up as this. code for third challenge juror. Okay. Okay, based on the Colorado court rules and statutes, there's no specific code for, oh, yes, there is a specific code. So the Uniform Jury Selection and Service Act, which is Article 71 of Title 13, and the Colorado Rules of Civil and Criminal Procedures. So then it starts talking about the grounds for a challenge, right? Okay. Standing in the relation of guardian, ward, employer, employee, principal, or agent to any party of being the member of a family or a party. Okay, qualifications, key Colorado juries, right to the jury service, qualifications, term of service, and challenge of juror pool. Okay, here's what we want to talk about. Challenge of the juror pool. Okay, it's Title 13. This is over in Just a Law. Okay, if I can find something over here that's going to discuss that. I'm going to bet it's got to be somewhat close to Texas. I mean, most of these states, well, ooh, that's 6 pages. Let's see. I'm going to turn it around this way so I can actually see it on my phone. All right, go away. Eligibility, here we go, all trials. Let's see. Before dismissing a person with a disability, that's what we're talking about. Qualifications, any person who was a United States citizen and resides in the county or lives in such the county more than 50% of the time, whether or not registered to vote, shall be qualified to serve as trial or grand juror in such county. Okay. A prospective trial or grand jury shall be disqualified based on the following grounds: being under the age of 18, which is smart. We wouldn't want a 17-year-old there trying to make a decision like that.
Right.
Inability, if you cannot read, speak, and understand the English language, you are disqualified. Inability to, by reason of physical or mental disability, render satisfactory juror service. Any person claiming that this disqualification shall submit a letter if they are to their jury commissioner requesting that from a license. Okay, so you need a letter from a physician that says that you have whatever disability it is, and you're going to submit it to the juror commissioner in that county. Okay, so then it starts going on about there's that sole responsibility, selection of service, appearance. I'm trying to find one where it starts talking about the one thing we're looking at. Okay, with the court, let's see, persons entitled to be excused. Okay, I think it's going to be right here in this section. Persons entitled to be excused from jury service. The General Assembly finds and declares, and this is the state of Colorado. Okay, that it is the policy of the state that all qualified citizens have an obligation to serve on juries when summoned by the courts of this state, unless executed in accordance with the provisions of this article. And it's talking about it shall be excused temporarily from service as a juror if he or her would cause undue extreme physical hardships, like if you have children at home, something like that, or you cared for somebody who could not care for themselves. The provisions of this subsection shall apply to notwithstanding the fact that persons does not have sole responsibility for the care of another person as described. Well, that's not what we're talking about. I want to find the one section to see if it says the word sometimes like it does in the Texas. Okay, a person, oh boy, length of jury service, extended trials, alternate jurors. Now let's talk about alternates because the jury in question was an alternate. The court may direct that one or two jurors, in addition to the regular panel, be called and impaneled to sit as alternate jurors. Alternate jurors, in the order in which they are called, shall replace the jurors. Okay, so we're going to use initials. So if JB, which we know is not the right initials, but if JB was number 12 or number 13 in the jury pool, and QB was number 18 in the jury pool, then JB is going to be pulled first. They don't, it's not a flip of the coin or it's anything, it's next in line. So that is how this juror ended up on being part of the jury, handing down the Senate or handing down its what's the word I want to use? That's how he ended up on the actual jury panel instead of just being an alternate. So I guess there was, hey Cinderella, how you doing, girl? Good to see you. We're just discussing how this person ended up being on the jury when they were an alternate in Leticia Stauch's case, because it's a big problem here, let's see. So the challenges, okay, challenge to array. Any party may challenge the array of jurors by motion setting forth particularly the causes of challenge, and the party opposing the challenge may join issue on the motion, and the issue shall be tried and decided by the courts. Okay, challenge to individual jurors. So it's the preemptory. I never say this right. The preemptory challenge. We're going to call it the preemptory challenge. Yes, for cause may be taking one or more of the following grounds. Okay. Number one is the qualifications prescribed by the statute to render a person competent. Okay. Number two, the affinity within the third degree to a party. So this is what we're talking about, this third degree to a party situation here. Okay, so then it says, let's see, um, standing in the relation of the guardian and ward, master and servant, employer or clerk, principal or agent of other parties, or being a member of the family of any party, or a partner in business with any party, or being um, what is this way? Or being security on any bond or obligation for any party. How does that? What's that got to do with the relationship between father, son, that kind of thing? Because that's not what it's talking about. Okay. See, it's saying something completely different over here. That's so wild.
Mm-hmm.
Alternate jurors, challenge to array, challenge to individuals, challenge for cause. Okay, standing in relation. Yeah, and where is it talking about that? Ooh, I hope this is no. Oh no, that's page 6 of 6. I know this can't be all of it. That's Rule 347B-C from the county courts. hmm Let's see. Expressed as unqualified or beliefs. Let's see. Interest in the part of the jury in the event of the action or the main question involved in the action, except the interest of the jury as a member or citizen of a municipal corporation. Okay, this is crazy. It is very different than what Texas says. Uh, you cannot be a juror if you were a witness in a previous trial. Okay, standing in relatives of guardians and wards. See, that's all it says. It's standing in the relation of guardian and ward, master and servant, employer and clerk, principal and agent of either party, or being a member of the family of any party, or a partner in business with any party, or being secret, or being the security on any bond or obligation of any of the parties. So it really never says exact wordings like Texas. So the word sometimes may not be the answer here. It might be something else. It'll be interesting to find out though, won't it? So
Yeah.
I'm excited. I mean, I'm not excited. I'm excited because I want to know what the answer is, but I'm not excited that if it turns out what we think it's going to be because of what the pressure it's going to cause. So I'm going to go pull this back up from yesterday, and that's our 182-page appeal. So we can talk about that for a second. For Mr. Murdaugh. Mr. Murdaugh, he's over in his cell just having a big time going, I'm getting out of here. I'm getting out of here. I always wonder, though, well, there's no way he's going to get bonded out, even while he waits,
No.
because he's in jail for other things. Okay,
Mm-hmm.
so let's find this over here. Why? Oh, this is interesting. Why the Alex Murdaugh appeal has entered dangerous territory. Whoops. Okay, let's watch this for a second. All right. Oh, no, I'm not going to. Now, this is going to be from CNN News, okay? So let me go over here and share the screen for a second so we can talk about this, because they're very in-depth about what they're having to say. Let's share this. I wish my dog would not bark over there, silly boy. All right, here we go. Now, I'm going to have to do some reading because it's not a video. As you can see, we got to read it. So let me go back over here and pull it down here. I'm just going to read while you watch chat, okay? Before
Okay.
oral arguments, why the Alex Murdaugh appeal has entered dangerous territory for the state. What the South Carolina Supreme Court can do, and why February 11th may redefine jury integrity laws in South Carolina. And I think it should. And absolutely, this should have never happened. When the attorneys for Alex Murdaugh appeared before the South Carolina Supreme Court on February 11th, the justices will not be revisiting the facts of a notorious double murder. They will be confronting something far more consequential, whether than a conviction can stand, when the court official entrusted with protecting the jury later admitted under oath that she lied during the proceedings tied directly to that trial. Now, I've always had this question, and it may be inappropriate, but I'm going to ask it anyway. I've always had the question of, did she do this on purpose because she wanted him to get a new trial? Think about it. I know it's far fetched. I know it is. But would somebody intentionally cause chaos in the trial if they were getting paid to do so somewhere down the road? We know she was going to make a book. She was going to write a book. We know she was going to sell this book. Was there some weird thing like that? I don't know. Don't know. It's interesting. So the
It's hard to
course said,
say.
yeah, it's like, oh, it's kind of like this the Leticia Stauch. Did the attorney, did Mr. Tortellini intentionally not? Would you do that? I mean, someone could all. I mean, I would never do that, but there are very unscrupulous people who would take and do any. They would do anything for money, you know. But I mean, she was already planned on writing the book, and she already had somebody who was going to publish the book for her. So I don't know if that is. I don't know about that, but but as far as Letitia Stouch's trial goes, did Mr. Tortellini intentionally use all of his strikes so that he had no strike left to ensure that she had an appeal? That's another question. I know it's a weird way to put it, but would somebody do that? It's a possibility. The court's acceptance of Murdaugh's motion to supplement the record has fundamentally altered the posture of the appeal. For the first time, South Carolina's highest court will review jury tampering claims. Oh, go away. Uh-oh. Fred Astaire and Loretta Young. Oh, somebody famous died today. Okay. Uh, for the first time, they will review jury tampering claims with formal knowledge that the former Colton County clerk, Becky Hill, pled guilty to jury obstruction of justice and misconduct in the office, all stemming from the conduct conducted to the Murdaugh proceedings. That reality did not exist when the trial court denied a new trial. It now sits squarely before the Supreme Court. Okay, so we're going to look at this. So yesterday they each had 40 minutes, but we know it took 3 hours or so. I mean, that was a long oral argument that they had, but it was very, very, I really enjoyed listening to it. Okay, so oral arguments is not a referendum on guilt or innocence. Instead, it allows the court to probe legal issues preserved in the appellate's recording, including allegations of jury interference by a court official, which this never happens. I mean, I don't even know if there's any case law that's talked about this before. I would like to know. We're going to have to look that up too. See, we're going down the rabbit hole here because I'm like, okay, one thing leads to another to be looked at.
Hmm.
Whether the court constitutionally standards were applied, whether harmless error analysis was appropriate, and whether the integrity of the jury process itself was compromised. That's a question. So, the appeal before the record had changed. In its original briefing, the state repeatedly minimized Becky Hill's conduct, characterizing her interactions with the juries as just foolish and fleeting, and insisting that the jury convicted Murdaugh because he was obviously guilty, not because of outside influence. The state's position depended on two propositions. Number one, that Hill did not meaningfully advocate for a guilty verdict, and number two, that the improper conduct was harmless. But here's what the Supreme Court knows now. The supplemental record accepted by the court includes Hill's perjury indictment. I mean, the perjury indictment was huge. I mean, that almost automatically granted him a new trial, but we'll see. Arising from false testimony given under oath on January 29th, evidentiary hearings before retired Chief Justice Jean Toll. Her sentencing sheet reflecting a guilty plea to perjury under South Carolina law, documentation of guilty pleas to obstruct of justice and misconduct in the office, including granting after-hours access to sealed trial exhibits to members of the media. Okay, now that was completely wrong. We'll talk about that for a second. She absolutely went in there and it was horrible. She absolutely went in there and let members of the media look at the trial court's evidence, basically, and she had no right to do that. I don't know what was wrong. I think they paid her money to do it. I think what I understand was there's some kind of money that changed hands on that. But how can you be that hard up for money? I mean, she was an
Yeah.
elected official. It makes no
Yeah.
sense. You know, Cinderella
Destroy
goes,
your whole life and your career.
right. She goes, I wouldn't do it either. She could still write her book without doing the jury tampering. She absolutely could. I mean, it was completely uh, I think it's really one of the worst things that a court official could do. That's even worse than okay. So there's a little thing about the transcripts from the court reporters. If a court reporter does not turn in the transcript, it is a cause for a new trial, and it doesn't matter if it was a murder trial or if it was a divorce trial, whatever it was. It is cause for a new trial. This has happened. It has happened here in the state of Texas. And when this happens, the person that is a court reporter loses their license to be I mean, they can never be a court reporter again. It's stripped because they
Yeah.
refused to they refused to turn it in. When I've known somebody who did that, and well, we'll talk about that later. It was just disgusting. Anyway, so we know that that happened. So at that time, the evidentiary hearing, Justice Toll stated Hill was not completely credible. What the court did not know then, and what the Supreme Court must now confront, is that her testimony was not merely unreliable, but criminally false. Why this is not a harmless error case? Murdaugh's attorneys
That's the
argued
key word there is criminally false. That's the key word, criminally.
criminally, yes, yes. Murdaugh's attorneys argue Hill's conduct constitutes a structural error, invoking the U.S. Supreme Court President's holding that jury tampering by a state actor is presumably prejudicial. The defense emphasizes that Hill was not a private citizen, but an elected constitutional officer responsible for the jury supervision, and that her authority, secrecy, and personal motives render traditional harmless error analysis inadequate. I have to agree. I have to agree. The
Hmm.
reply, the reply brief goes further, arguing that courts cannot rely on juror testimony to cleanse a verdict when the misconduct involves a court official under color of authority, particularly one who later admits to lying under oath. The question before the court is now whether the evidence was strong or but whether the process was constitutionally sound. Well, it wasn't sound because again, she admitted what she did. We've heard it. I mean, we've heard it under oath. We watched. I don't know if you watched her being sentenced, but I watched her being sentenced. So from Erb to Murdaugh, what precedent matters? The Supreme Court recent decision, State versus Erb, and this is the case that we need to look at, and we will pull it up. Let me read this. In Erb, the court overturned a murder conviction and barred retrial. Listen to the words barred retrial, emphasizing that the public confidence in the jury trial is constitutional interest in its own right. The court rejected after the fact rationalizations based on strong evidence, holding that constitutional process cannot be excused by persuasive outcomes. These are very important words because if you overturn a conviction, here we realize they have the court can say, and you're not retrying them. So if the court says you're not retrying them, they walk away. Imagine
Hmm.
that. Imagine that happening in Leticia Stauch's case.
Oh,
My God, that would be the worst ever. I feel like. While Erb involved double jeopardy, a mistrial, the underlying principle applies to courts may not rescue verdicts tainted by systematic failure simply because guilt appears clear. The reasoning dovetails with Green versus State, which is authored by then Justice George C. James Jr. Uh, it's George C. James Jr. Kittredge. That's a long name, isn't it? Which recognizes that some errors are so corrosive to a trial structure that they defy harmless error analysis. Jury independence, the court has repeatedly held, sits on the core of the justice system in the state of South Carolina for the Supreme Court. So let's look up this herb. Is it herb? Is that the one where they? Yeah, let's look this up. We're gonna look this up really fast. Y'all hang on. I think it's kind of interesting. Okay. Um, let me see. The state versus herb. Oh, here it is. Look, guys. Ooh, ooh, ooh. Can you see that? Okay. Let me see what it says. The petition for rehearing is granted. We dispense further the briefing of the attached opinions established for the previous opinion, which is withdrawn. Okay, what does that got to do with it? I want to see the next page. Um, I think I can see the next page by hitting this. Oh, did it go down? I think it did. Oh, it did. Okay, here's the question. Let me go up one so I can read the whole thing instead of just parts of it. Okay, I didn't realize that was going to work. Okay. On writ of certiorari to the circuit court, I know I say that wrong, I always do. And here's all the people involved, all the attorneys, the assistant attorneys, the defenders, the petitioners, everybody involved. So all of those people, I'm not going to read them all. Justice James, we issued a common law writ of certiorari to the circuit court to determine whether the trial court erred in finding that the state may retry John Joseph Erb for murder after issues arose during the jury polling at the conclusion of his trial. We reverse the trial court and hold double jeopardy bars Erb from being retried for murder and voluntary manslaughter. So they couldn't try for either one now. On March 20th of 2020, Erb was arrested for the murder of Donald Blake. He was indicted on the sole count in August of 23 and was tried 1 month later. In 1 month, they tried a murder trial? That's extremely fast. The record
Mm-hmm.
contains, that's very fast. I mean, it's taken years usually. The record contains no details of Blake's death other than the allegations in the indictment that Erb committed murder by blunt force trauma. The trial court, Judge Bentley J. Price, instructed the jury on murder and the lesser included offense of voluntary manslaughter. After deliberating for more than 5 hours, the jury advised it had reached a unanimous verdict. The trial court correctly read the verdict from the form and into the record as not guilty. Oh, listen what happened. The court made the mistake and read not guilty. Oh boy, that is bad. This is interesting. The trial court correctly read the verdict form into the record as not guilty for murder and guilty for manslaughter. The state declined the trial court's offer to poll the jury, but defense counsel requested the polling. The first 10 jurors polled answered yes to the two polling questions. Is this your verdict? With the follow up, is this still your verdict? The 11th juror polled hereinafter, which was jury number 16 was his actual number, answered to no to the follow up questions of whether it was still her verdict. The trial court immediately sent to the juries back to the jury room without ordering the jurors to continue deliberations and asked the attorneys if they wanted to go give an Allen charge. Now, I'm not sure what the Allen charge is, but we'll find out, I guess. So it goes, Erb obviously intended for polling to be only the voluntary manslaughter verdict, as the murder for verdict was not guilty. So he would have been found guilty of voluntary manslaughter. Okay. In his writ order ruling Erb could be retried for murder, the trial court stated and sent the jury out with instructions to continue deliberations toward reaching a unanimous verdict. That is not borne out of the transcript. The transcript establishes that after juror 16 was polled, the trial court said to the jury, you'll have to return to the jury room. Immediately after the jury departed, the trial court began discussing the proposed of an Allen charge with counsel. Allen versus United States, the typical judicial mechanism for encouraging an indecisive jury, is the Allen charge, in which the juror is instructed, oh, go away, little thing, which the jurors are instructed on. I'm sorry, we got to go down one. On defense counsel's expressed hesitation of the revealed split of the jury, and the trial judge told the attorneys to hang tight before he left the courtroom for 14 minutes. When the judge returned, he asked the bailiff to bring only juror number 16 back into the courtroom. Before the bailiff brought the juror out, the defense counsel stated, Judge, may I ask what the plan is here? In response, the trial court stated, I'm just going to ask her what she wants to do. I mean, if she thinks it's futile to continue to deliberate, I'm going to declare a mistrial. Okay, so if she didn't want to continue to deliberate, he was going to give a mistrial. If she says, I just lost it, I think I can talk to my friends. What? Wait, I just lost it. I think I can talk to my friends. I just got to see what she needs to do. You can't talk to you can't talk to friends. I mean, what? This makes no sense. Oh my God. Listen to that statement again. I'm going to ask her what she wants to do. I mean, if she thinks it's futile and to continue to deliberate, I'm going to declare a mistrial, which is proper, okay? If she says, I just lost it, I think I can talk to my friends. I just got to see what she needs to do before I make the decision. That, no, no, that makes no sense. Defense counsel objected, arguing to the questions of one juror would be coercive, and I believe that too. I agree with them. The state expressed the same concern and requested the trial court to instruct the jury to continue deliberations. Despite both parties, the request had not been Despite both parties' request that he not question juror 16 directly, the trial judge did not instruct the jury to continue deliberations. Instead, the trial court summoned only juror 16 to the courtroom and said to her, so you indicated that it was your verdict and then it was not your verdict. Only one question is that is me allowing you a little bit more time to deliberate that if it be futile. Juror 16 answered, yes, sir. It was always not guilty, and I just wanted to get it over. Oh, listen to that statement. Okay, this is dangerous. Yes, sir. It was always not guilty, and I just wanted to get it over with because they were all in there screaming and yelling at me, and I'll never change my like it's not guilty. Okay, you see what they were trying to coerce her. Okay. I'm sorry, without asking for input or argument from the parties, the trial court immediately said, bring the jury out. When the remainder of the jury was seated, again, without seeking input from the parties, the trial court immediately declared a mistrial, stating that the jury, we have to get 12 people to agree, and we weren't able, so I'm going to declare a mistrial. Okay. Approximately 1 week later, the state published a trial roster with Irv's murder charge listed. Irv petitioned for the habeas corpus and moved that the alternate for entry of verdict pursuant to Rule 29 of South Carolina Rules and Criminal Procedures. Both requests for relief were based on the ground that jeopardy attached to the murder. Okay, this is weird. That jeopardy attached to the murder indictment because the jury returned a final verdict of not guilty on the charge. Judge Price denied relief in the written order, stating the pertinent part of the charge. Because the pertinent part of the jeopardy is not attached to the above referenced charge, leaving the state in a position to retry the defendant for murder. Wow, this is interesting. I've never seen this before. We're number 5. Okay. The trial court denied Irv's motion to reconsider, and Irv appealed to the Court of Appeals. He also petitioned the Court of Appeals for writs of supersedes and habeas corpuses. The Court of Appeals dismissed the appeal, finding the trial court's ruling was not immediately appealable. Okay. The Court of Appeals also denied Irv's petitions for supersedes and habeas corpus. We denied Irv's petition for writ of certiorari to the Court of Appeals, but issued a common law writ of certiorari to the Circuit Court to review only that portion of the trial's court ruling that provides the state may retry the defendant for murder. In his brief, Irv argued jeopardy has also attached to voluntary manslaughter. Because our initial common law writ pertained only to murder, we asked for the supplemental briefing on the manslaughter issue, which the parties provided. We addressed both issues in this opinion. This is interesting. I've never seen it done I've never seen this I've never seen this. Okay. In the state versus Kirby, we addressed a claim of double jeopardy, also known as former jeopardy, and stated the theory of former jeopardy presupposes that the imposition of the ejectory gauntlet only once when it is accused of a crime. Okay. This guarantee consists of 3 separate constitutional safeguards. Number 1, protection from prosecution for the same offense after acquittal, which is exactly what they were trying to do. And number 2, protection against prosecution for the same offense after conviction. And number 3, protection from multiple prosecutions for the same offenses after an improvidently granted mistrial. Okay. Boy. The safeguards that derive their constitutional proportion through Article 1. Section 12 of the South Carolina Constitution and the Fifth Amendment of the United States Constitution, made applicable to the states through the Due Process Clause of the 14th Amendment, which is Benton versus Maryland. We're not going to go to that one. We don't have time. So here's the citation. Okay. Article 1, Section 12 of South Carolina Constitution provides no person shall be subject for the same offense to be twice put in jeopardy of life or liberty, nor shall any person be compelled in any criminal case to be a witness against himself. The Fifth Amendment of the United States Constitution provides an impertinent part that no person be subject for the same offense to be twice put in jeopardy of life or limb. Damn. Okay. The determination of whether jeopardy has attached is a question of law, which we review de novo. And it's gives another citing right there. Before we begin our analysis of the jeopardy issue, we must address what got us here. The trial court misguided. Okay, they're blaming it on the trial court. Okay, the trial court's misguided decision to question juror 16 individually. While polling rarely results in juror changing their mind, it does happen. This is why parties request pollings after an unfavorable verdict, so the trial court should have been prepared to act accordingly. After juror 16 was polled, the trial court should have stated that it was apparent the jury had not reached a unanimous verdict, and then instructed the jury to continue to deliberate and to let the court know when it reached a unanimous verdict. This is true regardless of whether juror 16 was the first, the fifth, the 11th, or the last juror polled. Both the solicitor and the defense counsel correctly argued individual questioning of juror 16 would be improper, but the trial court ignored their input. Had the trial court heeded the arguments of the counsel and instructed the jury to continue to deliberate, the situation we face would likely have been avoided. If the jury continued to deliberate, it might have eventually returned hung, or with a verdict of guilty on murder, or with a verdict of not guilty on murder and guilty on voluntary manslaughter, or with a total of not guilty at all. Okay. Isn't that interesting? So
Mm-hmm.
hold on a second. So we come over here, and so what's happened here is now the trial court has made error after error, even after being told by both the prosecutor and the defense attorney, hey, this is improper, this is improper. You don't see this very often. You don't see this very often at all. B, we hold double jeopardy bars a retrial of both the murder charge and the lesser included voluntary manslaughter because the trial court improvidently granted a mistrial. If in a criminal trial, a mistrial is declared without an absolute necessity for it, the mistrial or its equivalent to an acquittal and may be pled as a bar to a subsequent indictment. Oh boy, and then here's all the citings for that particular rule. A genuine inability of the jury to reach a unanimous verdict constitutes a manifest necessity for the declaration of a mistrial. And then there's those. If one juror indicates discomfort with the verdict, the trial judge should instruct the jury to continue deliberation. And there's the citings. Here, the trial court did not instruct the jury to continue deliberations, and instead it made the snap and erroneous decision to sponte declare a mistrial. The state does not defend the trial court's erroneous decisions to question juror individually. Instead, the state argues the results of the polling caused the verdict to implode in a way that revealed that the numerical split of the jury, thus rendering lots of long words, right?
Yeah.
Rendering a mistrial. They could have said this in so many less words. Just the mistrial, the only proper alternative for the trial court, juror 16 was the 11th juror polled. So her response indeed revealed at least 10-1 split on a voluntary manslaughter. The last juror was not polled at the time of polling. They should have polled the last juror. They should have stopped right there. However, after jury 16 was polled, it was apparent the jury had not yet reached this unanimous verdict. Any implosion of the verdict was not brought about by the result of the polling. It was brought about by the trial court's mishandling of the results of the polling by questioning juror 16 individually. The state does not address the obvious defect and instead jumps straight to the argument that the Allen charge would have been ruled coercive and had the trial court opted to give one after polling. This misses the point. He had the trial court simply instructed the jury to continue deliberating, and the jury later advised the trial court it could not reach a unanimous verdict. Then the trial court would have had to decide whether an Allen charge should have been given. In the United States versus Dorn, a tax return preparer who was charged with filing fraudulent income tax returns for clients, and then there's the citing. After the jury was sworn, the prosecution called one of the defendant's clients to testify, and a question arose to whether the client and other clients slated to testify that had been advised of their rights to remain silent when they were initially questioned by the authorities. Okay. The trial court sua sponte declared a mistrial so the issue could be resolved. When the case was recalled for trial before another jury, the same trial court ruled jeopardy attached during the aborted trial and the defendant could not be tried again. In the United States Supreme Court, they agreed, noting that whether one examines the circumstances surrounding the discharge of the jury, it seems abundantly apparent that the trial judge made no effort to exercise a sound discretion to assure that, taking all the circumstances into account, there was a manifest necessity for the sua sponte declaration of the mistrial. So it's like he just flew off the handle and said, okay, I'm tired of doing this. It's a mistrial. We're done. Didn't even try to work through it. The State versus Benton, we recognize the double jeopardy clause bars a second prosecution unless the mistrial was declared due to manifest necessity. Okay, that is high degree of necessity to further the ends of justice and preserve public confidence in fair trials. In Benton, considering different circumstances, we held the trial court did not improvidently grant a mistrial, and so holding we noted. Oh gosh. The trial court the trial court consciously considered alternatives to the drastic remedy of declaring a mistrial. The trial court abused its discretion in declaring a mistrial when it did so without allowing either party to object or request a continuance. So there's that, explaining that. Now we're fixing to be on page 8, which is the end of this. Thank God. This is a lot of reading. So there was the manifest necessity test cannot be applied mechanically or without the attention of the particular problem confronting the trial court. And then here's the citing for it. Here the trial court considered no alternatives to declare a mistrial. The trial court disregarded the arguments of the parties and afforded neither party the chance to object to its decision to grant this mistrial. The following observation of the Supreme Court in Jordan fits this case to a T. When one examines the circumstances surrounding the discharge of this jury, it seems abundantly apparent that the trial judge made no effort to exercise a sound discretion to assure that, taking all the circumstances into account, there was a manifest necessity for a sua sponte declaration of a mistrial. Okay, it goes. We hold the trial court sua sponte declaration of a mistrial colored by its mishandling of the polling results, and it was not manifestly necessary. Jeopardy attached to both the murder and the voluntary manslaughter charges. For the foregoing reasons, we hold jeopardy has attached to both murder and voluntary manslaughter. Therefore, the state may not retry Erb for either offense. And that's who signed it. Now, think about that for a second, folks. This man actually did kill somebody, and he walks away. He walks away because the trial judge did not handle it properly, and he just flew off the handle with his mistrial because he was upset about what happened in the polling. That's a scary thought. Oh my God. My God. I couldn't imagine. I wonder how that family feels knowing that the murderer of their family member will not be tried now because of the trial court's mistakes. That's bad news. That's very bad news. Okay. Now we're going to go back over here and we're going to talk about Mr. Murdaugh again. So we've read what happened in the Erb trial and why it was considered double jeopardy. After reviewing the briefs of record and oral arguments, the court will deliberate privately. Several documents are legally available. Oh, can we go look at them? What can we do after review? Affirm the convictions, and the court concludes no constitutional violation occurred or that any error was harmless. Murdaugh's murder convictions and life sentences will remain intact. Okay. Remand for further proceedings. The court may order additional fact-finding or application of the correct legal standard, and remand can expand inquiry rather than the narrowing of it. So they could just say, okay, we're going to look at this again. Okay. And then there's the reverse option. Reverse and orders a new trial. If the court determines that the jury process was irreparably compromised, it may reverse the convictions and remand for a new trial. If reversal would not acquit Murdaugh, he would remain incarcerated on his final. Okay, this is what I wanted to know about. He will remain incarcerated on his financial crime convictions while prosecutors decide whether to retry the case. So even if he gets a new trial and they decide not to retry the case, he's still not getting out because his financial crimes were lengthy terms anyway. I would hate to know that Maggie and her son never had never received justice because if they choose not to retry him, because he's still in jail for the rest of his life. That would be horribly wrong. But the cost of retrying this case is going to be enormous. Enormous.
Oh my God, yes.
I think Miss Becky should be held liable for part of the money. Think about that for a second. Yeah. Cinderella is like, when this was happening, I didn't feel good about it. Oh, I hope that the picture is AI and Murdaugh is in orange in front of, yeah. See, but here, remember that Leticia thought she was going to go to court whenever she was getting her appeal done. She just knew she was going to be sitting in that courtroom. I found it so funny that she was not. And did you notice yesterday, Mr. Murdaugh was not sitting in that courtroom either? Thank God. I don't think they need to go over there and enjoy talking to other people and seeing other people they haven't seen for a while, just because there was some kind of error in their trial. Um, I know that sounds mean, but I don't think they need to be out and about. I don't think they don't need to be back in the county jail getting the county jail treatment when they should be in prison. Now I don't know if county jail treatment is any worse or any better than prison treatment. I have no idea, but because I've never been there and I don't want to be there. No, thank you. What else did they say could happen here? Now, the bottom line is, okay, if a new trial is ordered, this is what it's going to look like. The case returns to the circuit court. The original murder indictment remains valid. The no reindictment, they don't have to reindict them. The pretrial motions reset, evidence, venue, and jury. And any Becky Hill related taint is removed. Oh no. Any Becky Hill related taint is removed. So does that mean I wonder how that affects the evidence. How does that affect many different things? The statements. Because listen to this. If Becky Hill let these people just come and see the evidence where they had no business seeing the evidence, and the evidence is now tainted, they can't use it. Think about that for a second. hmm I wonder how the cell phone is going to be looked at. Think about the cell phone situation. And remember, they talked about that yesterday in the hearings about when the light came on and when the light did not come on. But yeah, that's kind of scary, folks. That is scary. That statement right there. Any Becky Hill related taint is removed. That means anything that she had, anything, the evidence, the state, whatever it is, it's all got to be removed and it cannot be used in the new trial. Oh, God. That's a scary thought. The state may optionally seek a superseding indictment to streamline its theory, but it is not required to do so. Here's the bottom line on this new trial. February 11th will not be a procedural formality. It will be the first time South Carolina's highest court publicly grapples with a fact that did not exist during earlier proceedings, that a sworn officer of the court entrusted with safeguarding the jury in the most scrutinized trial in the state's history later admitted to criminal dishonesty and connected to this trial. Whether the reality compels a new trial remains to be seen, but the question can no longer be avoided. As the Supreme Court has already made clear in Erb and Green, the Constitution protects the integrity of the process as fiercely as it protects the outcome. How the court applies the principles to Alex Murdaugh may determine not only the fate of one defendant, but the future boundaries of juries' integrities and the laws in South Carolina. Okay. Swamp justice. Swamp justice. Okay, that's funny. Let's see. So apparently, Swamp Justice is some kind of a radio or a TV or some kind of a show. So I'm going to have to give full credit to Swamp Justice on this discussion. But look at all of this. This is Mr. James Seidel. But look at all these other things where you can look at Crimecast. We can look at some of these and maybe come look at his work sometime. He might have information on other cases that we've never even seen. Some new true crime to look at. Yeah. All right, we'll get off of there for a second. Let's get off of there for a second. So that is going to be what's going to happen in the trial of Mr. Murdaugh, and it's going to be terrible, just terrible. Because there's no timeline. We don't know how long it's going to take. I would think in this situation, because it was so blatant what happened, that the opinions will be written rather fast. In Leticia Stauch's case, I don't think they'll be written that fast because it'll be questioned the word sometimes, I think. Sometimes. So anyway, that's all I have on that. Um, oh boy, listen to this. Somebody reported something and it got struck and taken down. That's one. Okay, great. Thank you. Let me respond to her. Thank you. All right. Okay, I'll talk to you about that in a little bit about what that. So anyway, that is the deal with I was going to say Cinderella. I'm sorry, girl. That is the deal with Alec Murdaugh. Let's go ahead and go over here and look at. Oh, I know what I want to look at. I want to look at Nancy Guthrie. Let's take a look right now because so many other things have happened today in that case that I want to know about. I've not really looked at anybody else's channels to see what's going on in this case. CNN's disturbing video of a person. This is from 26 minutes ago. Let's take a look real quick. Let me see if I can pull this up. All right. Now, let me see. I'm going to have to share the screen. Hang on. We'll share the screen, guys. Here we go. Dun, dun. Okay. And it's titled Disturbing, let's see, Disturbing Video of a Person. How's it go? Disturbing video of a person. Come on. And the developments. Okay, let's read it. A disturbing video of a person questioned, and here are the key developments in this case. This is from 26 minutes ago, and it's full credit to CNN. We've all seen this video from yesterday, but we'll play it again. Let me make sure it's showing up, and we'll play it again. There it is. Okay, I'm gonna hit play. Okay, hang on for a second. We're gonna listen to this for a 2nd. There's the video. Look at it. I can't make it any bigger. I wonder what he thought he was doing. Oh, maybe I can make it bigger. Hang on. Oh, look, there's sound. Hello. That backpack. Look at it. Look at that backpack. See, I don't understand this. I don't understand. Why is he going over here to get a flower? What is this flower going to do? You think he's going to tuck it up in there and then people won't see what he's doing? I mean, I thought he broke the camera. This is kind of strange. We can see him trying to tuck it up in there. Does it cover it up, really? Ah, okay. Look, it is covered up, guys. Look at that. All right, now let's go read it. I'm going to read, and you watch chat while I read. That's how we work this. The search for missing 84-year-old woman Nancy Guthrie, mother of Today Show host Savannah Guthrie, has stretched into a second anguished week, with mounting pressures on investigators and family grappling with uncertainty. Guthrie was last seen on January 31st. Of course, we know that. Apparently, it's a kidnapping. We know that. The long days since she has vanished have been marked by disturbing twists, purported ransom notes demanding millions of dollars, and intensive investigations, emotional video pleas from Guthrie's children publicly begging the return of their mother, and officials releasing videos of an armed, masked person tampering with a doorbell camera at Guthrie's home. Now, I do remember seeing yesterday that somebody had put up, and it was completely AI generated, and it was something it looked like him taking her out of the house. It is not real. It was AI generated. I just want y'all to know that, okay? So, then let's keep on going. So where we were, okay. Nancy Guthrie and her family. This is what happened on the 31st. In case you don't know. Oh, look at that cute purse right there. See that? It looks like a camper van. Oh, that's cute. Nancy Guthrie joins her family for dinner and again Saturday night evening. Ubering to her older daughter Annie's nearby home around 5:32. Hours later, the family members drop her back home. Guthrie's garage door opens at approximately 9:48 and closes at 9:50. It is that time that we assume Nancy's home and probably, she's going to go to bed. Pima County Sheriff Chris Nano said that the news conference, and they're trying to say that her disappearance had to be sometime around then, I guess. This is where I'm a little bit confused. On February the 1st, continue reading. Guthrie's doorbell camera is disconnected at 1:47 a.m. About 25 minutes later, the surveillance camera software detects movement. At 2:28, data from Guthrie's pacemaker app shows the device was disconnected from her phone. Okay. Now, Sprinkle was telling me something this morning about they may have found this pacemaker somewhere else. So I'm not sure about that. We're trying to verify that information because I am not spreading misinformation about this case or any other case. I'm not doing it. More than 9 hours later, at 11:56 a.m., the family realized that she's missing when checking on her at home. A person close to the family told CNN Guthrie typically spends her Sundays watching the virtual church services with friends at a nearby home. When she did not arrive Sunday morning, her friends just alerted the Guthrie family. That would scare me so bad. Relatives called 911 at 12:03 to report her missing, and the Pima County Sheriff's Department patrols. They arrived at 12:15. Investigators scour the scene, finding blood on the front porch, which is later confirmed to be Guthrie's. There is still more items that have been submitted. We just haven't got them back yet, the sheriff would later say on February the 5th. In the meantime, we're not just sitting on our haunches waiting. We do have a number of leads coming in. I think there was like 4,000 leads in 24 hours or something. It's a huge amount, not leads, but call-ins. People try to give information. On the third day of the search, Guthrie and several media outlets, including TMZ, CNN, and affiliates of KGUN and KOLD, received purported ransom letters demanding millions of dollars in Bitcoin for her return. One note includes a first deadline of 5 p.m. Thursday, February the 5th, and a second deadline of February the 9th. So, see, when you have two, they start giving you different deadlines. That tells me it's not a real ransom note. I think somebody was just trying to use, somebody stepping in trying to use this situation to take advantage of these people, thinking that they could just squeeze money out of them. And I know why they think they can, because you heard the family saying, "Oh, we'll pay, we'll pay, we'll pay," right? And an
Right.
emotion, yeah. I mean, that would. And I'm pretty sure there's been two different. I think it's two different people sending these notes. I don't think it's just the same person. Didn't they arrest somebody for one of them? Is that what I remember?
Yes, they did. Yeah, they did.
Okay.
Then he bonded out.
Uh-oh. But he's not going to be so stupid as to send another one, would he? I know
I
people
would
are
hope
dumb.
not.
I mean, people are dumb. Think about it. In an emotional video posted to Instagram on Wednesday evening, Savannah Guthrie, flanked by her siblings Annie and Cameron, pleads for her mother to come home 4 days after her disappearance. We need to know without a doubt that she's alive and that you have her. Guthrie said in response to the reports of ransom notes, "We want to hear from you and we are ready to listen. Please reach out to us." That would give a lot of people ideas. I know it would. That statement right there, anybody could take that statement if they were stupid. Well, stupid people and think, "Oh God, they'll pay anybody. They're desperate. They'll pay anybody." So law enforcement actively suddenly increases Wednesday early evening as detectives perform a follow-up at Guthrie's home. The shift office, the sheriff's office says fresh crime scene tape wraps around the length of the house and is taken out within a matter of hours. Why wouldn't they leave the tape up? February the 5th, Cameron Guthrie issues another plea in a video posted on social media at 5 p.m. local time as the first deadline given in the purported ransom note passes. "Whoever is out there holding our mother, we want to hear from you," he says. "We haven't heard anything directly. We need you to reach out. We need a way to communicate with you so we can move forward." They sound desperate, right? The FBI, now jointly
Mhm.
working with the case with Pima County Sheriff's Department, announces a $50,000 reward for information leading to the recovery of Guthrie and or the arrest and conviction of anyone involved in her disappearance. So sadly, even the first guy that they arrested from his ransom note, um, I hope he doesn't think he's going to get that $50,000. Imagine that, crazy asses. Anyway, it's not funny. None of it's funny. It's really sad. On February the 6th, CNN affiliates KOLD receives a new purported ransom note on day 6. The news station says it forwarded the message along with the IP address from which the notes originated to law enforcement. The new note includes sensitive information, but no deadline, according to the anchor at the news outlet. Well, I'm glad they were able to track the IP address. That's good news. Later that evening, but here's the thing about that. If they were able to track that IP address, these people were pretty sloppy, because if it was a real
Yeah.
criminal, they would have known to cover that, right? Think about
Yeah,
that
for
for a
sure.
second. Later that evening, gloved investigators are seen buzzing over Nancy Guthrie's property, placing evidence markers and climbing onto the flat, stark white roof of her home. Agents peer into bushes and scour the ground as a car, which appeared to be Guthrie's, is towed away. February the 7th. I really haven't paid this much attention until right now. February the 7th, 1 week mark of her disappearance, her three children say to her possible captors in a new social, "We will pay. We received your message and we understand." Savannah Guthrie says the new video, "We beg you now to return our mother to us so that we can celebrate with her. This is the only way we'll have peace. This is very valuable to us and we will pay." Boy. Hours after the new video of the siblings, law enforcement officials are seen at Annie Guthrie's home. They leave shortly after 10:30 p.m. with a bag, and one deputy sheriff saying is seen wearing blue latex gloves. February the 8th. Just before 11 a.m., investigators return to Nancy Guthrie's home and are seen examining the septic tank near her property. Video shows investigators moving around a long stick in the tank at times, repeatedly jabbing it. Oh my God, how horrible. And using a flashlight to peer inside. Detectives and agents continue to conduct follow up multiple locations. The Pima County Sheriff's Department says the CNN affiliate KGUN, KGUN, which received the first ransom note sent to some media stations, reports new details from the letter. The purported abductors demanded $6 million and threatened Guthrie's life at 5 p.m. Monday, February the 8th, or the 9th, the deadline isn't met. February the 9th, around 1:30, hours from the second deadline in the letter, Savannah Guthrie posted another video to social media, this time appealing to the public instead of her mom's alleged captors asking for assistance. We are at an hour of desperation. We need your help. Today, the Today Show host says, telling people to report anything strange to law enforcement. The second deadline in the purported ransom note passes at 5 p.m. So over and over, this is passing over and over. Look at these pictures, guys. Look at that. Look at that one right there. See that right there? I mean, it kind of looks like that picture I put up. I didn't put it up. I had, you know what I'm saying.
So
I don't want to be
scary.
accused. It is scary, and I don't want to be accused of anything. It shows right there on the picture that I made. I asked Chat GPT to put the mask on the other guy, and that's exactly what it showed. The FBI releases new images and videos around 11 a.m. from a camera at Nancy Guthrie's house showing a person wearing a mask. You know, I bet that person is pooping their pants. Think about this. They thought they were not going to be seen. They had to think they were going to be able to hide themselves. But you can see their eyebrows, you can see their lips, you can see their mustache. I mean, it's very easy to try to figure out whose eyes those are. The images show an armed individual appearing to have tampered with a camera at Nancy Guthrie's front door the morning of her disappearance, according to the post on FBI Director Kash Patel's X account. The video was recovered from the The video was recovered from residual data. I was going to say residential. um, Residual data located in the back-end systems, Patel wrote in a post. I guess because if you have this type of system, like if you have CASA or one of those other programs where you can look at your camera from anywhere, even though it's not there, the information is still going to be in that system. That's what we use. We use a thing called CASA and our with our cameras. And I mean, we even when we were on the boat in Mexico or wherever we were traveling, we could see inside, we could see outside of the house. We had a camera inside the house, so we knew if the dog sitter was at the house or not with these dogs. It's not that we didn't trust the dog sitter. It's just that I need to know what's going on in my house because these dogs can be a lot. you they're cute as they can be, but they are a mess. The video, okay, so shortly after the images of the videos were released, Savannah Guthrie shares them to her social media accounts. Someone out there recognizes this person, she writes. We believe she's still out there. Bring her home. Later Tuesday, the Pima County Sheriff's Department announces it has detained a person for questioning in this case after pulling them over during a traffic stop in Rio Rico, Arizona, around 60 miles south of Tucson near the U.S.-Mexican border. Hours later, early Wednesday morning, that person was released. And I believe there was somebody, I saw a video of that person telling about their experience. I'd like to know why they pulled him over. What made them think that he needed to be pulled over? Was his car seen on that street at some point? I mean,
No,
that's,
because his mother-in-law saw the picture and said that it looked like his eyes.
oh my God, how horrible. What a
Hmm.
mean mother-in-law. That's a mean mother-in-law. Think
Yeah.
about it. Separately, Patel says the agency is looking for persons of interest in this case without saying who might be under suspicion. February the 11th, the release of the surveillance video begins generating thousands of tips for investigations to pour over. TMZ reports the media outlet received a bizarre letter from someone purporting to know Nancy Guthrie's kidnapper. Harvey Levin, the outlet's founder, told Fox News that the person who sent the email demanded a single Bitcoin in exchange for information about the kidnapper. Oh, that's dangerous. They are not saying that they are kidnappers. They are saying they know who the kidnapper is and will give the information for 1 Bitcoin. They said they want Bitcoin sent to a Bitcoin address that we have confirmed is active. It's a real address. And as they put in it, time is more than relevant. TMZ says it received the note just before 8 a.m. Eastern Standard, I guess, a.m. ET. I guess that's Eastern time, and that the sender claims to have tried unsuccessfully to reach Savannah Guthrie's brother and sister via text message. TMZ says it sent the new email over to the FBI. When asked by CNN about the new note, the FBI says, outside of our previously issued statements, we have no updates to share at this time. Oh, that's kind of scary. CNN has not been able to independently verify the existence or the authenticity of the note and has reached out to the Pima County Sheriff's Department for comment. Meanwhile, CNN speaks to Carlos outside his home in Rico Rio. Who is Carlos? Is that Thomas?
I'm not sure.
I'm not sure either. He says investigators told his family he had been stopped as the guy. I'm sorry,
It must be
Carlos
the
is the guy.
guy.
Yeah.
Yeah.
Stopped as a result of an anonymous tip that came after surveillance photos of the subject were released Tuesday. They said that my eyes and my eyelashes look the same, Carlos said. A law enforcement official familiar with the case later told CNN that he was on the investigators' radar before the images were released. What? Wait a minute. Wait, time out. How? How? How does this guy play
That's
into all of
weird.
this? It is weird, right? How does it play into it? Has he been seen on the street? I mean, yeah, something's weird about this. Is he part of this band member? I mean, how does he know one part of the family? Uh, okay. A law enforcement official familiar, okay, says that. When asked what he wants after the interrogation, responds to clear my name. That's all I want. Amen, brother. I get it. Amen. People need to leave you the hell alone. If you have nothing to do with it, leave you the hell alone. On February the 12th, as the search for Nancy Guthrie enters its 12th day, neighbors are asked to review their security footage from 2 days in January as investigators work to piece together a potential new timeline in the case, according to the post shared on the neighbors' apps, by the Ring Camp by Ring, their neighbors app by Ring. Oh, their neighbors app. Like there's that neighborhood app. Yeah, we all have that, or a lot of places have that. Investigators are said to be looking for footage from later in the day. Investigators expanded the request for surveillance footage to include video between January 1 and February the 2nd. Ooh, that's a long time. Ours doesn't store it that long. Ours only stores like 48 hours. Okay. According to an alert the department shared on the neighbors app by Ring, the Pima County Sheriff's Department asked neighbors to submit video footage that includes cars, traffic, people, or pedestrians, anything they feel may be out of the ordinary or important for law enforcement to review. Investigators also said to be looking into evidence discovered at Guthrie's home, including gloves. It is unclear if the gloves are connected with the person in the doorbell camera footage. Oh, okay, that's important because for some reason I thought, and Sprinkle, didn't you also think that they had found the actual gloves the guy was wearing somewhere close to the house? I think that's what I remember. Were you there? Did you hear what I said, Sprinkle, about the guy and the gloves? Hello. I guess she's not listening. Okay. Well, she's gonna get a deduction. I need to get my big fat pencil. She's gonna get an F. She's not answering the question. Anyway, so investigators are also said to be looking at evidence discovered, including these gloves. It's unclear if the gloves are connected with the person in the doorbell. Savannah Guthrie also shared a touching tribute to her mother on social media. The video features a short dip of young Guthrie and her sisters Annie smiling at the camera while handing their mothers flowers, as well as a
Oh,
photo of three siblings and their mother. We will never give up on her, Guthrie captions in the post. There is a correction. Correction. An earlier version of this story incorrectly reported the time frame that residents are being asked to share footage from January the 31st. The alert did not specify whether it was morning or night. Okay, and that is from CNN. All right, so that is what's going on in that case. What else do we want to talk about? We've been on here about an hour and 19. I mean, this is kind of interesting stuff. I hope they find her safe, but it's been so many days. For me, it's been so many days. I'm so afraid. Oh, she fell off. That's why she's not over here. Hey, girl, get your butt back up here where you belong. There she is. All right. Did you hear what I asked you, Sprinkle, about the story? What do you think?
I got booted out. I couldn't hear you. They
Okay.
kicked
All right.
me out. Yeah.
Well, damn. I was asking about the Nancy Guthrie story, how strange it was about the days that they're looking. Well, I mean, if somebody told me look at your cameras from this date to that date, it wouldn't matter if they said morning or night because I would have started looking at midnight from midnight that day
Hmm.
and all the way because that's when. Okay, I don't think I don't think yeah, see, Cinderella, I don't either. It's been way too long. And if that pacemaker, well, the pacemaker, all the monitor does is let you know if it stops because actually a battery runs this pacemaker. I don't know if y'all know this or not, but a battery runs this pacemaker. And so, unless the battery goes out, there would be no reason for it to stop. But then you got to wonder if she's on medications. I mean, she's 84 years old and they say she's pretty healthy, but she is on some medications. Um, you gotta wonder though. Let's see about that story. Remember the story we were talking about the pacemaker? Let's see if we can find that story. Y'all hang on. Let's see, Nancy Guthrie. Okay. Pacemaker found. Let's see. I heard something about that today. Remember? Let's see if this is true or not. Let's see if there's anything out there about this. Okay. Okay, so here we go. I found a little story. Let me read this right quick. Nancy Guthrie's pacemaker was initially reported to have been disconnected from her Apple device around 2:28 a.m., but it continues to transmit data to her doctor indicating she is alive. Well, I don't know about that because the only way the pacemaker stops is if it's removed. In other words, the battery dies or the funeral home removes the pacemaker. This is the way I understand it. I could be wrong, and I don't want to say anything wrong.
Hmm.
Yeah, Nancy Guthrie, 84, was last seen, so we know about that. So let's find out about the pacemakers. Let me find out when does the pacemaker stop? Pacemaker. Pacemakers in general, when do they stop? Let's just look that up that way. Pacemaker. When do they stop? After death. Oh, that sounds terrible, and I hate to say that. I hope this poor little lady's alive, but it's just been too long. So,
It's been too long.
oh, this is interesting. A pacemaker stops effectively when the heart and the body cease functioning, allowing its battery. Although its battery may continue to emit electrical pulses briefly, which cannot revive the heart. Okay, so this is how a pacemaker works. This is what I wanted to know. Here we go. A pacemaker is a device designed to assist a living heart by sending electrical impulses to stimulate contractions when the heart's natural rhythm is too slow or irregular. It consists of pulse generators, which contains a battery and a circulatory and leads that deliver these impulses to the heart muscle. The device relies on a functioning circulatory system or electrically conductive tissue to complete the circuit and trigger. Okay, so it does not stop unless the heart stops. That's interesting because that is exactly what I did not know. Okay. When death occurs, the heart and other vital organs stop functioning, and the body's electrical and circulatory systems cease to operate. While the pacemaker's battery may still generate the signals for a short period, the impulses cannot cause the heart to contract because the myocardium is no longer responsive. The phenomenon is sometimes observed as an electrical mechanical dissociation, where electrical activity is present, but the heart cannot pump the blood. Therefore, the pacemaker does not prolong life or restart a dead heart. That's interesting. So, end of life. Pacemakers generally do not need to be deactivated at the time of death unless it is requested by the patient or the family, often for ethical and comfort reasons. In cases of cremation, pacemakers are typically removed beforehand because the high temperatures can cause the device to explode due to its lithium batteries. Woo! Removal is a minor procedure performed by trained personnel and ensures safety during its cremation. That is kind of interesting, right? It cannot operate independently after death. Okay, so there's the answer. If she was not alive, it would not be operating. This is good news. This is good news, really good news. Okay, so Cinderella says, allegedly, law enforcement asking for videos from neighbors and cameras on January the 10th. Oh, good, good. So they think somebody saw her and planned it. Well, somebody had to plan the whole thing. There's no other way that could happen, right? I mean,
Yeah.
nobody just randomly knocked on her door and said, "Oh, I think I'm going to take you today." That is not how this happened. But
No.
I've just wondered the whole time, what is the reasoning? Why would they take this 84-year-old woman? What did they what did they think they were going to get? I mean, they made the ransom notes aren't even from the right people. It as far as I understand, the ransom notes are just from people claiming to be involved just to make easy money. It's just like a ruse. It's a prank. Just a prank to get easy money. I don't know. What do you think, Sprinkle?
Yeah, no, I agree. It's just terrifying that look. Poor family. I can't even imagine what they're living with right now.
Me neither. I mean, yeah, the money. Cinderella says it's the money. I mean, that's a really nice house, and I don't know what her family did. I don't know if they were. I don't know if her parents were independently wealthy. I don't know anything about the family, but I do know that's a very nice house that the mother was living in. I mean, it could have been perceived that this lady had some money, but they didn't. Maybe not. But whoever kidnapped her maybe did not realize her true financial picture. They may have realized it
Yeah.
after they kidnapped her. They may have realized that her true picture was not what they thought. Which would be horrifying if you stop think about it. Because now, how do they return her? They either have to one return her and get arrested, or number two, don't return her and hope that they never get arrested. Because either way, if they return her, she's going to speak and she's going to know who it is. I think she knows who it is. I think that she would have never knowingly left with somebody she didn't know. What do you think? Because
Yeah.
even if there was a little blood, why didn't nobody? I guess her driveway was so far back, nobody could see anything from the road. Is that what we understand? Yeah.
Yeah.
It's $4 million. Yeah, $4 million. Damn, Cinderella, that's an expensive house. Yeah. So it's kind of fascinating how they even got her. How did they get her out of there? It seems like it happened so fast. That's why they had to have been casing the place. They had to know her, know the family, and know something about that house. No, that's the only way they could have gotten her out of there like that. So I think it's interesting. It's interesting to watch. So anyway, I would.
Yeah.
Yeah.
Cinderella, I wonder too if she opened the door if they forced their way in because I wouldn't have opened the door if I had seen somebody like that on my camera.
But the door. It's like the door was not damaged. So did she look out the camera and see somebody she knew? Did she look out, or did she forget to lock the door, or did she think the door was locked but it really wasn't? I mean, who knows?
Hmm.
At 84 years old, let's just face it, we don't always remember everything we're supposed to be doing. Hell, at
Right.
65, we don't always remember everything we're supposed to be doing. you know?
Right.
Yeah, yeah. So, anyway, that's what I'll. Anything else I want to talk about today? I mean, I didn't have much. I just wanted to talk about the appeals and poor Nancy Guthrie and things like that, and the other situation that I don't really want to hear anything else about. And let me just explain something to you that was told to me because when I asked about where those videos were, thank God somebody answered me. She goes that this situation had been reported and those were taken down. And so when those were taken down, that also took away those clips. So
Hmm.
there you go. So I'm hoping that this puts an end to all of it because I am sick to death of hearing somebody keep on going and going, going like they know somebody personally. You don't know me. You don't know nothing about me. You you never even asked me anything. How can you say these kind of things? You don't know me. Oh God, I don't know you, and I'm not going to sit around here and say things like that about you. Why would you do that to somebody? It just goes to show how low people can go. You know. So sorry, her house is worth 800,000. Listen, the house is 800,000, but she personally is worth $4 million.
Oh
That's
wow.
still a lot of money, Cinderella. I'm not worth no $4 million. I know I can't come up with $4 million. Period. Shit, that's a lot of money.
Mm-mm.
Damn.
That's a lot of money. I wonder why she
Yeah.
was worth so much.
Well, you know what? Let's do some investigating. We got the machine right here. Let's take a look. We're going to take a look right quick, and we'll just keep talking for a few minutes. Okay. Why, or let's say how, here we go. Nancy Guthrie worth so much. Here we go. Let's see what it has tells us. Oh, it's going to chat and GPT, I think. Okay, it's thinking about it to tell me. It's Copilot's telling me this. Oh, listen to this, guys. Listen to this. Hang on. We're going to share the screen real quick. This is interesting. Let me share this screen because I had no idea. Window. Um, is it right here? Nope.
Her wealth is
Look at this.
derived
Look at
from
this.
long-term homeownership, her
Okay.
savings, and her late husband's inheritance.
Yeah, because it won't let me show this one tab over here, which sucks. All right. Yeah, it says why people assume that Nancy had money. Public interest in her finances support only or surged only after her disappearance and the ransom related chaos, not because she was known to be wealthy. The reporting shows a few key factors. Number one, her late husband's inheritance. Nancy's primary financial foundations came from her inheritance from her husband, Charles Guthrie. He was a mining engineer who died in 1988. This inheritance appears to be the largest contributor to her long-term financial stability. And this is from Bollywood something. Number two, the long-term the long-term home ownership in Catalina foothills. Okay, she owned a long-time home in the Catalina area of Tucson, which naturally appreciated in value over decades. Media attention on that home's value fueled speculation about her net worth. Frugal, steady life rather than high income. Nancy worked at the University of Arizona in public affairs role, which helped her support her family but did not generate significant personal wealth. Reports emphasize that she raised three children alone and lived modestly. Okay, so I guess her children were rather young when her husband passed away. Her disappearances created a vacuum of information, and the public began assuming she must have been wealthy if someone targeted her. Several outlets explicitly note that her net worth is modest, and the attention is driven by this case, not by the actual evidence of major wealth. That's interesting. The bottom line, Nancy is not known to be extremely wealthy. Her perceived worth came from, as you said, decades old inheritance, a home that appreciated in value, and media speculation tied to her kidnapping, not her actual finances. That's interesting. Okay, now we know that is the problem. So here we go. We have people that think she's worth a lot of money, but she's really not. So could they have actually kidnapped the wrong person? Could they have kidnapped somebody that was not what they thought? What made them think that? You know what? Maybe it's the kind of deal. I just feel like this had to be somebody she knows. It just has to be somebody she knows. I don't think it's a stranger. I just don't. And they always talk about
Yeah.
what. Wait a minute, it's quicker than. Look at this. I know you can't see what I'm seeing, but there's some really weird note up here about your browser has blocked something. Click the screen icon. What screen icon? Here. I don't know what it's asking, but we'll click this.
Huh.
Okay, we're fine. I know we're fine. It can see us. I'm going to get rid of that message. There we are. We're good. So I think maybe, I do think it's, like they always talk about, well, people that are kidnapped or stranger danger, that kind of thing, that really it's typically it's less than 1% of people are actually kidnapped by a stranger. Most of the time it's somebody
Right.
somebody you've met, right? Or a family member. What family member? And I mean, something's just weird about this whole case. I wish I knew what it was. I wish I knew what it was, but
Yeah, it's very strange.
yeah. Oh, yeah.
I hope
It
they
is
at least
strange.
return her or find her one way or the other, you know?
Every that's the thing about these cases. Every family needs closure. When somebody's missing from your family, well, this applies to Sebastian. It applies to all of them. All of them. It
Hmm.
applies to all of them. They need that closure. I mean, even if they're not with us or with their family anymore, or there's no way to recover, well, they still need to recover because there still needs to be closure. That's the hardest part, I think. I think, I
Right.
think, I think for these families who've had children missing for a long time, they're just never found, and these parents are just going through life every day, wondering, "Where's my child? Where's my child? Where's my child?"
I
They
can't
it's not
imagine.
I don't think it's like people think it is. I mean, you and I have closure. We know where our children are. No matter what happened to them, we,
Right.
we do have that closure. I cannot think that Katie or Seth or even CP. I don't think any of them are walking through life like, okay, well, outside. I don't believe that. I don't believe that at all. I'm never going to believe that. I believe that every day they're living with a pain of where is Sebastian? What in the
Yeah.
hell? Where is this child? Why can't I find him? The questions because they don't have answers. Somebody has
Hmm.
answers. I'm not going to blame anybody because I don't really know, but somebody has answers. But it's still, for those who don't have the answer, it's got to be just horrible to walk
Yeah.
around like this every day. It's going to be 2 years soon. 2 years. And just look at, yeah,
Monkey's mom, you know, little
yeah,
monkey.
yeah. Look at that
I
situation.
can't
Oh,
imagine.
that's going. Listen, we got to keep up with that because that's going to trial. The first part of that trial is coming up, I believe in
Yeah,
March. I believe it's in March. Is that right? Let's look it up
I
real
think
quick.
so.
Okay. And what's that guy's name? It is oh damn,
Stacy
Stacy
Wandra.
Wonder. Yeah. Let's figure out when his trial is happening. Okay. Oop, not Wander. Stacy Wonder. Stupid. It's trying to take me to state to Wander a flower. I didn't know there was a
No,
brand called Wanderer. Okay. Okay, let's see. Let's see. When is his trial? Come on now. Oh, no wonder because they put flour in there. That's too funny. I've heard of Wander bread, but not Stacy flour or Wander flour. That's so funny. Um, Trial. This is fun. Okay. There's his affidavit of arrest, court records, just type in the name. Let's see. Criminal cases, case lookup. Let me see if he's going to tell us when his trial is going to start. This was July. This case is so old. July 20 of 27 of 2021. And then here's something else on his disappearance in 2022. There's so much information over here.
I
And
know.
there's the K9 team. Where is this child? I want to know, where is this child? Let's go over this for a second. Let me pull this up. Hang on. Can I share my screen? Let's see if it'll let me show this. Hang on, guys. Oh, here we go. Here we go. I think it will let us show it. Photos. Let's see. Yes, you can see it. Yay. Okay, I'm gonna do some reading. So you watch while I do the reading. So Fayette, Idaho. This is from May 17th. Newly released court documents outline a disturbing and detailed account of what investigators say happened to 5-year-old Michael Monkey Vaughn, who vanished from his Fruitland neighborhood on July 27, 2021. An unsealed probable cause affidavit accuses 4 individuals: Stacy Wanderer, Sarah Wanderer, Brandon Shirtliff, and Adrian Lucene. Is it Lucene or Lucene? Adrian Lucene. I think it's Lucene. I'm not sure. For participating in his abduction, death, and concealment of his body. Look, they know where this baby is. Why won't they speak? I don't
I
understand it.
know.
Fruitland police initially named all 4 suspects in Vaughn's disappearance in December. On Monday, more than 4 years after Michael's disappearance, Stacy Wanderer was arraigned in Fayette County courtroom. According to the detectives Juanita Keller and the Fruitland Police Department, Stacy Wanderer is alleged to have committed first-degree murder, second-degree kidnapping, and destruction and concealment of evidence. In the affidavit, Keller states the following: Michael's disappearance on July 27, 2021. A K9 team showed interest in the home of Stacy and Sarah Wanderer. During a search executed by Fruitland Police on August the 1st, the Wanderers' residence, officers discovered Adrian Lucien hiding in a closet. Why you gotta be hiding? A subsequent interview with officers showed that Lucien and Brandon Shirtliff were living with the Wanderers at the time. I don't understand. I will never understand why. Why would you pick this little boy up? What the hell did you think you were doing? Cell phone data and
Yeah.
surveillance footage indicates that all 4 were in the area when Michael disappeared. The affidavit also reveals that Lucien took a selfie inside the Wanderer bathroom around 7:26, during the same window of time that Michael went missing. Oh, Shirtliff trying to say, well, I was in the bathroom taking my own picture, so it couldn't have been me. Right, but you lived in the home. You knew about it. In addition, investigators say that live scent canine tracked Michael's scent directly to the front door of the Wanderer home. Multiple neighbors also reported seeing a pink Big Flyer tricycle reportedly connected to Michael inside the Wanderer's garage prior to his disappearance, down a nearby bluff after he vanished and later relocated behind a neighborhood sign. Fruitland police recovered the tricycle on August 5th. On Monday, Brandy Neal, Michael Vaughn's mom, bless her heart, told senior reporters Don Nelson that she did not believe the tricycle was related to Michael, as he typically rode a bike. Idaho News has reached out to the Fayette County prosecutor for clarification on the detail in the affidavit. Stacy Wanderer later told Fruitland police, while incarcerated in the Washington County Jail, that he witnessed his wife, Sarah Wanderer, carrying Michael Vaughn into their home on the night of his disappearance. Well, if you saw that, why didn't you call anybody? What was the damn plan? See, this makes me sick. According to the affidavit, Stacy proceeded to tell officers that Michael was then placed in a duffel bag with a duct tape. Okay, trigger warning. Sorry, folks. With duct tape placed across his mouth. Stacy also said Brandon Shirtliff gave Sarah the duffel bag and Adrian held the bag open while Sarah put Michael inside. That poor baby, he was scared to death. From there, Sarah, Stacy, and Brandon are said to have driven to Kuna in a GMC truck with Michael inside the duffel bag. Stacy said that by the time they arrived in Kuna, where Brandon's mother lived, Michael was no longer making any noises inside the duffel bag. Brandon brought the duffel bag inside the home and placed it in a spare room. The three proceeded to tow a Mercedes belonging to Brandon back to Fruitland. Stacy then claims that Sarah, Brandon, and Adrian returned to Kuna the next day to retrieve the duffel bag with Michael's body. Upon returning, Stacy stayed inside the home while Brandon stood guard as Sarah and Adrian dug a hole to bury Michael. Stacy Wonder said the motivation for the kidnapping was to sell Michael Bond, an ideal allegedly introduced by Adrian. Stacy said that Lucian claimed that they would get $10,000. Mm. While describing these events to the officer, Stacy Wonder began to vomit, citing stress related to the memory of Michael as the reason for getting physically ill. I hope it does make him ill for the rest of his life. I hope he sees this every time he closes his damn piece of shit eyes. After Stacy's interview, he participated in a video call with his mother. During the call, his mother asked Michael if Michael was still alive, to which he responded by shaking his head no. He then told his mother that Sarah accidentally killed him by suffocation. He then told her that they buried Michael in the duffel bag in their backyard. There's the affidavit. Okay. After the interview, and call, Stacy wrote an apology letter to Michael's parents before attempting to hang himself in the Washington County Jail. He was rescued by jail staff. Why? Should have let the bastard die. According to the documents on November 12, 2022, officers delivered a search warrant to Sarah Wander's home. While officers read the warrant, they said Sarah issued several bewildering statements. Wow, that's a lot. I definitely did not kill that boy. Sarah Wander went on to say that the Most High God just told me that Stacy was the one who killed him and buried him. You see how one's blaming the other? Of course, they're going to do that.
Mhm.
They're each going to do that. During the search of the Wanderers' residence, a team of cadaver canines was alerted multiple times to the presence of human remains. However, no remains were located during the subsequent excavation of the backyard. Detectives noted that several areas of disturbed or recently filled soil during the excavation. The affidavit also documents a dramatic shift in Sarah Wander's behavior after Michael disappeared, including the 329 TikTok videos of religious testimony posted and statements about breaking all 10 commandments. Investigators say the sudden escalation in her online activity began in mid September in 2021, shortly after the alleged burial. Stacey Wonder is scheduled for a preliminary hearing in December 16th. I want to know when they set this trial. As of Tuesday, only Stacy has been formally charged in the connection with Michael Bond's disappearance. Sarah remains in Idaho Department of Corrections custody on separate matters. Brandon is currently in the Canyon jailhouse, serving 30 days for failing to follow the terms of his previous release on his unrelated charge. According to the county spokesperson, he is expected to be released in early December. Why would you release him? He is a accessory to murder. Adrian was arrested
Right?
and released. Okay, so Adrian was released in Indiana in October for traffic related misdemeanors. Indiana authorities said they don't know his current whereabouts. Oh no, no, that's not right. Oh no. He needs to be charged too. Every one of those bastards need to be charged. Every single one of them.
Mhm.
This is sickening. Let me see if I can pull this up. Will it open? Uh, more actions. Let's see. I don't know if I can get this to open. Right, there's I would like that. I think I can get this. Hang on. Maybe I can get this to download. I'm not sure, but I want to talk about that for a second. But I know that there's an upcoming trial because I saw this. Oh boy. Let me see if there's anything else that's mentioning his trial. I feel so bad for that mom too. She's another one. It just breaks my heart to watch her go through this. But she's so strong, you know. She's so strong. She's been
Mhm.
through a lot. She's really been through a lot. Update. Let's see. When was this? This was 1 day ago. Let's watch this for just a second, okay? Oh, that's on their divorce, but maybe we'll talk about it for a second. So this is going to be to missing PMW. Yes, I like her. Mhm. Okay, here we go. Huh, I wonder why I can't see it. Wow. Can you see it? No, it's like I don't can't get it. Okay. Okay, we'll just listen. We'll just have to listen. Yeah, gross. Hmm. Let's see if I can find that. Find it over here. Okay. Okay. Very good. Oh. Mm. Okay. So March 3rd. Oh. Oh, there it is. Oh, there you go.
And that this circle of grief is never ending. So please pray for the Vaughn family and pray for justice
Oh
for
my
Michael Vaughn.
goodness. Okay, that's the end of that. All right, good.
For Idaho News 6, I'm Senior.
All right. So that is the question. That is the answer to that. Let me unshare my screen right there. All right, we're going to get off of here soon. We've been on here almost 2 hours, just talking about everything we could talk about. Thank you, Cinderella. I appreciate you so much. You know I always do. She and I do feel so bad. It is going to be so hard for them, but I'm so happy to know that March the 3rd we're going to start in on him, and I hope every one of them gets tried and charged. And I can't wait for his trial to start. I don't. I might see if I can live stream it. I don't know how to do that. I've never done that before, like to live stream a full trial like that. But I think it would be kind of fun to do it. I mean, I know other people will be doing it too, but maybe we can put our own spin on what's going on there, or maybe live stream it and talk about it at night. I don't know. We'll figure out something to do with it. I think it's very interesting. I hate that it's happening, but I'm so glad it's finally happening because she needs justice. She needs her baby back, and the fact that none of these mother truckers will give her baby back makes me sick. Absolutely sick. I don't understand how you could be so damn cruel. How can you be that cruel, you know? Oh, God. It's just hurtful. It's so hurtful. I've always said, you've heard me say this before. Oh, you've all heard me say that. If they would ever return that baby, I would help pay for that, for that funeral. Just like Harmony Montgomery. If they would ever tell us where that baby is, I would help pay for that funeral. I just want those babies to have a final resting place where their family can go see them and they're not just still out there missing in God knows where. So, everybody be careful out there. Be safe. Take care of yourself. Have a good evening. Enjoy the rest of your day. What do I always go? You can take us out, Sprinkle. Mm,
And hug your babies. Hug your babies.
that's right. That's right. Life is short. It's even shorter with them because they grow up. And that empty nesting is
Poor
hard.
babies.
Damn hard. Anyway, we'll see y'all all later. Have a good evening. Thank you
It
again so
is.
much.
It
Uh-oh.
is.
What was that noise?
Bye, buddy.
Okay, bye, guys. Uh-oh.